The opinions expressed on this program represent the viewpoints of individual authors or contributors and do not necessarily reflect those of Troy University.
Conversations. I'm your host, Dr. Dan Sutter of the Johnson Center for Political Economy at Troy University. The United States Supreme Court is the highest court in the land. Its decisions provide the final resolution of legal and political disputes in our country and consequently help determine the rules that we all must live by. The selection of members for the Supreme Court is consequently very important for us all. And not surprisingly, the selection and confirmation of members has become a contentious political matter. We often think the issues we face today are without precedent in history, but our nation has been selecting Supreme Court judges since George Washington served as our first president. Joining us today on EconVersations to discuss the selection process for the Supreme Court is Ilya Shapiro. He has written a new book on this topic, Supreme Disorder, Judicial Nominations in the Politics of America's Highest Court. Mr. Shapiro is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute in Washington, D.C. He earned a law degree from the University of Chicago and is a frequent commentator on nominees to the Supreme Court. Because we'll also be talking about the law, I'm joined today by Dr. Alan Mendenhall, the Grady Rozier professor with the Johnson Center here at Troy. And so he will be asking some of the questions of our guests, because Alan is a lawyer as well. And I might add, Alan will also be asking questions of his former supervisor at the Cato Institute. Well, welcome to the show, Ilya, and Alan, welcome back.
Thank you, Dan.
Good to be on.
Ilya, first of all, it's great to see you, even if virtually. I owe you a lot. You were my first job out of law school was working for you, so I've always been grateful to you for that. Your book came out in September, which is fortuitous in some respects. Justice Ginsburg passed away in December, leaving a vacancy that President Trump has sought to fill with the nominee, Judge Amy Coney Barrett. And I'm wondering, as we sit here today, 5 days from the votes on her confirmation, what was different about that confirmation process?
Well, the one thing I learned, and Alan, it's good to be with you as well. I guess you didn't screw up too bad. It was over a decade, but I've continued interacting with you, and I recall that your work product was at least adequate. So there you go. You seem to have done something with yourself. So that's good to see. What I learned in writing this book is that there's very little new under the sun in the long sweep of American history with these judicial nominations. And politics has always been part of the process. I mean, George Washington had a nominee rejected. A lot of our presidents, more than half, have had some difficulties for all sorts of reasons. It's not so much that every nominee necessarily has to have something different. I mean, she was not accused of being a serial gang rapist like Brett Kavanaugh. I'm sure that's not the point of your question. These confirmation hearings are really they're set pieces. Everyone plays their assigned role. The nominee talks a lot without saying very much, and is supposed to show how both nice and intelligent he or she is. And Judge Barrett certainly did all of that, just very disarming and Teflon. The Democrats couldn't get a glove on her really. So certainly not as contentious as Kavanaugh or Thomas or Bork. But these hearings, these contentious hearings, tend to happen when there's a potential for a real shift on the court, and certainly moving from Ruth Bader Ginsburg to Amy Coney Barrett would be such a shift. So you would expect, especially right before the election, for there to be fireworks. But there are no quivers, despite what Nancy Pelosi has said. There are no arrows in the Democratic quivers. Really, they tried to do what they could, but really making political arguments for the election, because Mitch McConnell seems to have the votes, and as you said, this coming Monday, it looks like unless there's something really out of left field that we can't expect, like half the Senate coming down with COVID, so they can't physically be there to make a quorum, she'll be confirmed.
Well, before we get into more detail about this, could you possibly remind us exactly how does this process work formally? Because that might help provide a little bit of perspective on how it is that politics jumps into this system. So how is it that we get somebody on the Supreme Court?
Sure. The Constitution doesn't say very much about it. So first it says that there shall be a Supreme Court and such lower courts as Congress may create. So Congress can create or eliminate, for that matter, lower courts, which they've done. As far as nominating the judges and justices, the Constitution says that the President shall nominate and with the advice and consent of the Senate shall appoint judges to the Supreme Court. What does advice and consent mean? Well, it's been interpreted to mean, whatever the Senate wants to do with it. And so there's a lot that goes in, especially in the early years, the first century or so. Most of the politics came in on the front end. Before the nomination was announced, the president would consult with his allies, make sure different people in the different regions of the country were satisfied, factions of his party, all those sort of things. Get your ducks in a row that way, then announce your nomination, and it's pretty much a foregone conclusion. Until some turbulent periods, the lead up to the Civil War, for example, only 8 of 21 nominees were confirmed after Andrew Jackson before Lincoln. Other periods much more smoothly, the 1880s through 1968, only 1 nominee was rejected. But again, in our long sweep of history, we've had lots of things happen. Nominees being rejected, withdrawn, declining to serve. The last one of those was about 150 years ago because it wasn't considered to be a very prestigious job. And if you were a prominent lawyer in Boston or Philadelphia or Richmond or what have you, why would you leave that to come to the swamp and work in the Senate basement, which is where the Supreme Court was. And we've had nominees not acted upon. Merrick Garland was not unprecedented, although it hadn't happened for more than 100 years. But the key thing to know in all of this is just politics cannot be understated. Political power, sheer votes. And so when the Senate and the White House are controlled by the same party, historically there's been about a 90% confirmation rate. When it's opposite parties, divided government, less than 60%. And the division in that statistic during presidential election years is even more stark. This is now the 30th time we've had a vacancy arise in a presidential election year. When during united government, 17 of 19 nominations have been confirmed. During divided government, only 2 of 10 have been confirmed. So that's it. Again, the advice and consent means the Senate can and individual senators can exercise their prerogatives as they see fit.
Ilya, people on both the left and the right decried the politicization of the nomination and confirmation process, but you raised the point in your book that that process has always been political. It's always been heated. When people look at what's changed, maybe they think about the fact that Justice Breyer was asked only 5 questions, whereas Justice Kavanaugh was asked over 1,200 questions. What is it that people are directing their ire at when they are alleging that the process is too political?
Well, to be clear, you were talking about the questions for the record, the written questions after the hearing. Breyer got they all get asked about the same number of questions. The hearings last the same number of days. But yeah, certain things there have changed. What's really different, it's not that all of a sudden politics becomes a factor. I mean, presidents are politicians, senators are politicians. There's going to be politics in this stuff. What's different now is, first of all, the substance of what the Supreme Court rules on. We've had over decades a centralization of power in Washington, and within Washington, within the federal government, a skewing away from the legislative branch, from Congress, to the administrative agencies and the executive branch. And of course, the deputy undersecretary of whatever can't be unelected, can't be voted out, can only be sued. And so the Supreme Court is ruling on more and more controversies because the federal government is bigger and because this dynamic with the administrative state. So you got that. The court is powerful, each of these seats is powerful, and at the same time, the confluence of several trends, or the culmination of these trends, where we have different interpretive theories mapping onto partisan preferences at a time when the parties are more ideologically sorted than at least the Civil War, if not ever. So, of course, with a zero-sum game, finite number of seats, whenever you have one of these precious, powerful vacancies, that is going to be a fraught battle.
You mentioned the different interpretive theories. If you could, very briefly, for those of us who didn't go to law school and wouldn't be able to follow too difficult, too intricate of an explanation, what are the major different ways to possibly interpret the Constitution these days?
Well, if anyone was watching the Barrett hearings last week, you heard a lot of talk about originalism and textualism. Those tend to be the theories predominant among Republican-appointed judges. The Federalist Society, which is a national group of conservative and libertarian lawyers and law students. Originalism means interpreting the Constitution, each provision by its original public meaning. So the First Amendment, ratified in 1791, what does the freedom of speech mean? Or the right to keep and bear arms under the Second Amendment. And that's why you look to everything from dictionaries to the Federalist Papers, which are essays explaining the Constitution at the time. Now, if you're looking at the 14th Amendment, the Equal Protection Clause as it applies to the states, well, then you look at 1868 when that was ratified. Again, when a constitutional provision came into effect, you look at the meaning of it, not what somebody intended, because there could be lots of intentions. Madison didn't agree with Adams, who didn't agree with Jefferson or what have you, but it's the words on the text when they were enacted that's paramount. And textualism is kind of like originalism, but for statutes rather than the Constitution. So the Clean Water Act, the Clean Air Act, the Civil Rights Act of 1964. Look at the debates, look at the dictionaries from the time, and you try to interpret the plain meaning of that text. That makes you a textualist. And you can debate that. It's not that all textualists or all originalists agree on everything. Certainly not. On the other side, it's kind of a more looking at what a judge might think the purpose of a law is, or kind of pragmatic considerations, or what is the way to achieve the just result or the fair result, or there's a theory called living constitutionalism, that the Constitution is a living document that grows with society, and so certain provisions might change in their meaning as kind of mores and our political culture changes over time. And so these are kind of more malleable, less bound to the text theories of interpretation that are generally associated with progressive legal thinkers.
Ilya, Earl Warren was nominated by President Eisenhower. George H.W. Bush nominated Souter. Ford nominated John Paul Stevens. And Nixon nominated Justice Blackmun, who was the author of Roe v. Wade. What is the likelihood today that a president might nominate somebody who would drift from their jurisprudential expectation?
I think very low, because the vetting has gotten more sophisticated in terms of looking at judicial philosophy and proven judicial philosophy, not just somebody vouching for a potential nominee, rather than looking at good party men or kind of nebulous characteristics of having worked in a Republican administration or something like that. It's much more we've been burned so many times on the Republican side that you want proof both of your theories and that you've applied those theories in controversial times, that you face the heat of whether it's the media or other sorts of things where that is consequential. But the other thing to realize is that there are external political factors that work different ways. Eisenhower appointed Warren not because he thought he would be the most, achieve the most Republican results, shall we say. No, Warren, who as governor of California helped Eisenhower in his presidential campaign, and he was a well-reputed Republican politician. So Eisenhower said, "Yeah, I'll put him on the court. That's a great way to reward your supporters." And he was a smart man. It's not that he wasn't qualified. He was a well-qualified lawyer. But eventually, as you alluded, Eisenhower said that he'd only made 2 mistakes in his presidency, and they were both sitting on the Supreme Court, with Warren and then Bill Brennan. But that, and by the way, Brennan was a recess appointment month before the presidential election of 1956. So we have had these election time controversies, but Brennan, everyone knew he was to the left. He was on the Supreme Court of New Jersey, had gotten a reputation. People knew that he was a bright kind of progressive star, but Eisenhower needed or thought he needed to shore up political support in the metropolitan Northeast. Didn't hurt that Brennan was Catholic as well. And yeah, that worked in the 1956 election. Eisenhower did really well in those areas. So Brennan served his purpose. I don't think even if Eisenhower didn't later like what Brennan did, it wasn't for jurisprudence that he was picking him. Souter was kind of a cipher, the stealth candidate. It was a overreaction to Robert Bork, who laid everything too much on the table and got attacked for it. And so a few years later, Republican president said, no, we need a conservative who has no track record, the perfect stealth candidate. Well, what you got was someone who wasn't really moored to any interpretive theory and did drift left like that. So now we've kind of, the conservative legal movement thinks that it's learned these lessons, and also the lesson of John Roberts, who has not moved left, but he's more beholden to strategy and being a minimalist, not moving the court too much or too far, thinking about things like legitimacy more than overarching legal theories. And so, okay, you figured out the Souter bit. Now it's Roberts. Clearly a conservative, worked in the Reagan administration, good Republican, but not an originalist or textualist necessarily. So these things evolve.
Well, recently, Joe Biden was asked about possibly appointing additional justices to the Supreme Court should he win the election. As you mentioned, there's nothing, the Constitution is actually sort of quite silent about the actual composition and structure of the Supreme Court. So at one level, it wouldn't be unconstitutional, would it, if there was a decision in January, we want to expand the number of justices on the court, is there?
Right. The Constitution does not fix the number. That's a federal law. We've been at 9, according to a federal law, since 1869. FDR famously in 1937 tried to pack the court because it had been ruling against his New Deal programs, and so he wanted to add one justice for every justice over 70 and a half years old. Coincidentally, the ones who were most against him were the older ones, appointed by Taft and others. And so this was hugely unpopular, even though FDR had been reelected in a landslide in 1936. His own vice president was against the court packing. The Chief Justice, Justice Louis Brandeis, a big progressive and friend and ally of FDR, was against it. The Democrats ended up losing 80 seats in the House and 8 in the Senate at the next midterm. But look, Roosevelt 3 years later got to pack the court the old-fashioned way. But by 1941, he had appointed 7 of the 9 justices. So in our history, there have been expansions. There have also been contractions, always for political reasons, that have not necessarily inured to the benefit of the party proposing them. There's a huge cost. The latest polling I've seen say 58% of the people oppose court packing, something like 30% support it. So if the Democrats get a majority in the Senate, along with Joe Biden winning, will those new senators from states like North Carolina, Montana, Iowa, Arizona, will they be willing to, one of their first acts, to get rid of the Senate filibuster, first of all, that procedural hurdle that you need 60 votes to proceed to a final vote on any legislation, and then add seats to the court? I don't know. And this is why Biden's being coy. He doesn't want to anger his base, and also doesn't want to turn off those swing voters who are generally against that sort of thing.
Among legal scholars and jurists, broadly speaking, on the right, including conservatives, including libertarians, there's a working debate right now about the role of either judicial restraint, as it was sort of traditionally called, and judicial engagement. Can you talk a little bit about those debates? And I know Cato Institute and you have been sort of at the forefront of moving this debate forward.
Right. So we talked briefly about interpretive theories. What is the proper interpretation of the First Amendment, or Congress, the scope of Congress's power to regulate interstate commerce? The debate over restraint versus activism versus engagement is not about theories of interpretation. It's about judicial modes. So how sure does a judge need to be that some congressional legislation goes beyond the Commerce Clause power to set it aside or to strike it down? What kind of rights should be protected? Unenumerated rights. What kind of justifications should the government have to show to restrict somebody's liberties in a given way? So there's obviously an overlay of interpretive theory on that, but I think the conservative legal movement, in responding to the Warren Court kind of making things up out of whole cloth, what got called activism, although now activism, I think, is just thrown around as a decision I don't like or a judge I don't like. It's kind of an empty phrase. But the response of the conservative legal movement, Robert Bork, early Scalia, and others, was no, you're being activist, we need to be restrained. And I think that's a mistake, because they're not, what they should have done is said, your theory of interpretation is wrong. Here's a better theory. They eventually did that, and that's why we've seen a greater and greater advent of originalism and textualism in the Federalist Society among conservative legal elites. But there's this underlying thing about restraint that's still there. And look, restraint leads you to what John Roberts did in the Obamacare case 8 years ago, bending over backwards to find some way to read the law in order to uphold it, to avoid going against the political branches who enacted the law. But that is the tension, as you said, kind of the more historic, traditional conservative view of judges being restrained and deferring to the political branches versus being more engaged, not activists, not making things up, but saying, look, my theory says this is the government's power goes here and no farther, or here are the rights protected. This is definitely one of those unenumerated rights. The government hasn't shown a good enough reason for why they want to take that away. But that's where the lively debate is, certainly in center-right circles.
No, I guess we've talked a little bit about the idea of precedent and judges making rulings consistent with their previous rulings, but that element is really important because these laws and judicial interpretations really sort of like shape our expectations in society. They tell us what the law is or what we're expected to do, and so that's a really important factor. Even if you think like a law might be wrong, it's shaping people's expectations, and that can make it a very difficult thing for justices or any of us to think about wanting to change the law, doesn't it?
Yeah, our confirmation fights talk about the role of precedent quite a bit, mostly because it goes to Roe versus Wade, which has been in place nearly 50 years now. But there's others as well, and the legal doctrine at issue here is called stare decisis, which is fancy Latin for just let the decision stand. And it means that, as you were saying, sometimes it might make sense to let an erroneous precedent lie uncorrected, because fixing it would disrupt social expectations, legal architecture, the ways people have set up their lives, their businesses, their affairs, in light of that decision. And so this doesn't necessarily track what interpretive theory you apply, or whether you're politically liberal or conservative or what have you. And in fact, famously, Justices Scalia and Thomas approached this issue of stare decisis, the strength of precedent, very differently. Justice Thomas has never really seen an erroneous precedent he wouldn't overturn. He says that reliance interests are overblown and people adjust, and you can, it's better to make sure that we're following the Constitution. Justice Scalia said, no, we have to be more cautious, and some things are just water under the bridge. Judge Barrett, who clerked for Scalia and considers him her mentor, has actually done a fair bit of writing about this, which is why it came up even more than normal during her hearing. She has an article called Originalism and Stare Decisis. What is the good originalist supposed to do when, by all accounts, his or her interpretation of a constitutional provision is different from the governing Supreme Court precedent in that area? And she talks about, it's a prudential consideration. How workable is that old rule? How old is it, for that matter? Have the facts on the ground changed? What kind of reliance interests are there? Is there really legal architecture? Is it something that people could adjust to fairly quickly? So again, these are not kind of principles. This is judges supposed to use their judgment and their wisdom and their prudence in thinking about those kinds of considerations.
Ilya, given the growth of the administrative state and the centralization of power, you end your book on an optimistic note, saying that possibly a way forward is a decentralization of power, or returning power to the states, something that prevents politics from being such a zero-sum game where you have two parties vying over this apparatus of power so that they can weaponize it against each other. Could you say a little bit more about that?
Yeah, the third part of my book, like Gall, my book is divided in three parts. The first part is the history, basically George Washington through 1968, which was a pivotal inflection point in our legal culture as much as in our political and social cultures. And then the second part, the modern age, the last 50 years roughly. And the third part looks at what have we learned and how can we fix it. And I talk about all sorts of reform proposals, from term limits, which I moderately favor, but they wouldn't really change the substance of the issues that the court rules on, or the ideological balance, to expanding the court, to restructuring it in different ways, changing the way the hearings work, all sorts of stuff there. But at the end of the day, all of these reform proposals are addressing symptoms. They're nibbling at the margins. They're rearranging deck chairs on the Titanic, because the problem isn't with the process so much as the product. The Titanic is the ship of state. As I said earlier, Washington has accumulated so much power, and therefore the Supreme Court and the federal judiciary has accumulated so much power. That's why we have these big battles whenever there's an opening, and that's descended to the lower courts as well the last couple of decades. And so the only way to fundamentally fix this and to detoxify, depoliticize all of this stuff is to rebalance our constitutional order, push that power back to the states and localities and people, and within Washington, fix our warped separation of power, so Congress is forced to make more of the difficult political decisions and compromises rather than punting it all to the courts. I mean, look, we have more demonstrations and protests in front of the Supreme Court than in front of Congress. That's a little bizarre, because Congress is where we're supposed to be hashing out our differences in policies or values or what have you, not leaving it up to 9 philosopher kings. And if we had 9 philosopher kings, as Justice Scalia was wont to say, why would we pick 9 lawyers for that job?
Well, that's a good way of thinking about it. I mean, and I think, certainly generally quite in favor of decentralization. I mean, what any final thoughts about, like, where we might be headed in the near term or in longer term here with the Supreme Court? Well,
let me be clear. Even if federalism and separation of powers were enforced exactly the way that I would want, it doesn't mean that the court would not be ruling on anything controversial. I'm still a big believer in the whole Constitution, including the 14th Amendment, which protects individual rights and liberties against violation by the states, by the localities. And so you'd still have questions whether about abortion or guns, or the state is improperly regulating my business, taking away my right to earn a living, or something like that. So you still would have those kinds of questions, but you would allow then states to have a lot more wiggle room, so that on any given issue, the court wouldn't have to be deciding between the California approach and the Texas approach. Each of them could go their own way, whether it be on healthcare or financial regulation or whatever the case might be. But I mean, there's no easy answers. That's my takeaway. I wrote my book to appeal to history buffs, to politicos, to those who are interested, obviously lawyers, people interested in the law and the development of our legal institutions. And I think there's a story to be told connecting all of those things. But where we've gotten to with these contentious confirmations didn't happen overnight, and there are no silver bullets or panaceas to change this, reverse the process easily overnight, particularly, as I said, as the parties are ideologically sorted. Maybe they'll be rebalancing now in our populist moment, who knows? But for the moment, with the parties apart and the interpretive theories apart and the court being powerful, you just cannot avoid these battles.
Well, thanks very much for coming on and joining us. We've enjoyed this very much, and thanks for joining us. Join us again next time for another EconVersations.